Prejudgment interest in Seamen's personal injury cases. Supreme Court precedent lost in a sea of procedural confusion. Since Erie Railroad Company versus Tompkins, it has been practically an article of faith that the choice of substantive law should not depend on the court basis for jurisdiction. As the Supreme Court subsequently explained, Erie rests on a notion of fundamental fairness that the accident of a suit under diversity jurisdiction in a federal court instead of in a state court a block away should not lead to a substantially different result. Notwithstanding the enduring force of the Erie Doctrine's animating principle, many lower federal courts consistently hold that an important aspect of the substantive law of damages under the Jones Act varies with the jurisdictional basis under which the district court hears the case. By the majority view, if the plaintiff brings a Jones Act case on the law side, prejudgment interest may not be awarded. But if the same case is instead filed in admiralty, then past damages may, in the judge's discretion, be augmented with prejudgment interest. In this article, we argue that with few exceptions, the lower court analysis of this issue is fundamentally flawed. In our view, the substantive law of the Jones Act should not be construed differently depending on whether the federal court that hears the case sits in admiralty or on the law side, nor on whether a state court rather than a federal court decides the case. Rather, the operative rule should be simply that, in whatever forum a Jones Act suit is brought, the plaintiff isn't entitled to prejudgment interest. Our conclusion rests on a simple syllogism, because the Supreme Court has made clear that, with only a few exceptions, the Jones Act incorporates the substantive law of the Federal Employers Liability Act, or FELA, and because the court has denied the applicability of prejudgment interest under FELA, the same result should apply under the Jones Act. We then extend this analysis applying the teaching of Miles versus Apex Marine Corporation to the general maritime law context. The confusion in the lower federal court warrants clarification and resolution. The availability of prejudgment interest in Jones Act cases is important to the proper administration of maritime law. The Jones Act is the central stated in the maritime tort filed and is litigated frequently. An even larger number of potential Jones Act cases are not litigated because the parties, based on their expectation of the likely result in court, settle them before filing suit. Because time inevitably passes between the date of the accident and the entry of judgment or other resolution of the dispute, prejudgment interest is an issue at some level in every Jones Act case. Even if interest rates were to remain low and cases were decided quickly, with the result that the amount of prejudgment interest in each case would typically be relatively small, the sums at issue would still be substantial in the aggregate simply because so many claims arise. But interest rates haven't always been low and are not likely to remain low forever, and many cases take years to resolve. City of Milwaukee versus Seamen Division, National Gypsum Company, a collision case, offers a striking example of how significant prejudgment interest can be. The prevailing party sought an award of over $5.3 million in a prejudgment interest on a damage award of less than $1.7 million and ultimately retrieved almost $6.5 million in a prejudgment interest. Jones Act cases also confirm how substantial prejudgment interest sums can be. In this article, we sketch the historical background to the applicability of prejudgment interest, define the scope of our discussion, survey the current state of disarray of federal and state court decisions addressing the availability of prejudgment interest under the Jones Act, explain why prejudgment interest should not be permitted in those cases, and conclude with some observation about prejudgment interest under the general maritime law. Some historical and procedural background. An injured seaman faces a variety of substantive and procedural choices when seeking compensation from an employer. Under the general maritime law, a ship owner is strictly liable to a seaman injured by the vessel unseaworthiness. In addition, the seaman is entitled to maintenance and cure, a no-fault remedy that is often analogized to workers' compensation. But as the Supreme Court explained in the Osceola, the general maritime law historically didn't offer the injured seaman a negligent remedy against the employer. Congress eventually filled this gap in 1920 when it passed the Jones Act, which gives seamen the same remedies that railroad employees may receive under FELA. Current law permits a seaman to combine all of these claims, unseaworthiness, maintenance and cure, and the Jones Act in a single action, and plaintiffs regularly take advantage of this option. Procedurally, a Jones Act plaintiff has the option of bringing a claim in federal court at law or in admiralty. Read literally, the Jones Act provides that the negligent remedy it creates is available only in an action for damages at law, an action on the law side of federal court pursuant to 28 U.S.C. 1331. In Panama Railroad Company versus Johnson, however, the Supreme Court construed the act to mean that the remedy may also be sought in an admiralty action under 28 U.S.C. 1333. The court's construction of the Jones Act in Panama Railroad means that a plaintiff who chooses to pursue the remedy on the law side of federal court is deemed to have invoked the saving to suitors clause of 28 U.S.C. 1333. From this interpretation, it follows that Jones Act may also be brought in state court. Regardless of the forum chosen for a Jones Act claim, a plaintiff naturally aims to maximize the recovery and thus desires prejudgment interest. Prejudgment interest is distinct from post-judgment interest in that the purpose ascribed to the former is to make the plaintiff whole by awarding interest on the damages suffered by the plaintiff between the date of injury and the date of judgment, whereas the purpose of the latter is to ensure that the plaintiff remains whole during the process of post-judgment litigation. The awarding of prejudgment interest has long been held by the Supreme Court to be part of the substantive law applied by the trial court based on two distinct considerations. One is that the proper measure of damages is inseparably connected with the right of action, and therefore is a substantive matter that must be settled according to general principles of law underlying the plaintiff claim. Second, the court has explained that what constitutes the proper measure of damages necessarily includes the question of whether prejudgment interest may be awarded to a prevailing plaintiff. Thus, prejudgment interest has been deemed part of the actual damages sought to be recovered because it is normally designed to make the plaintiff whole. In Manazan, the Supreme Court employed the reasoning to hold that prejudgment interest is a question of a substantive law under the FELA. At common law, prejudgment interest wasn't available in personal injury cases. In the 19th century, court began to award prejudgment interest on contract claims, and Congress began to confer right to interest on judgment in certain circumstances. Thank you.